It's precisely 3 o'clock, and I'd like to welcome you to our first ever remote webinar. I'll have some introductory remarks, give people a chance to sign on, and then we'll get into the meat of it. We have about 270 people signed up today, so it should be interesting. Unfortunately, interacting is complicated with that many people, as well as answering questions online in an active sense. I have so many questions that people sent in advance, so I'll answer those. I'll try to answer the other ones by email, and of course I'll answer some more next week. While we're waiting for everybody to log on, I want to extend my best wishes and the wishes from everybody at Ettinger Law Firm to all of you, for your families and anybody who's fighting the illness, loss of life which has happened even to employees, not employees, but family members of employees at this law firm. And I'm sure many of you have similar stories and situations. There's not much to say about it. We just hope the loss of life is minimalized and that everybody recovers as much as possible. I want to take a moment to thank our healthcare professionals, obviously, but also let's thank all the service people, people working in the grocery stores, the gas station attendants, the food delivery people, the Amazon workers, UPS, all of those people are taking greater risks than any of us are. And without them, we really wouldn't be able to get by. So they're keeping us going. I want to extend a thank you to all of them. As far as Ettinger Law Firm goes, we are working remotely. Everybody logs in first thing in the morning at 9 o'clock, and then we exchange information. We communicate with clients by phone. As you can see, we can communicate by Zoom, so we are conducting Zoom appointments. We're also conducting remote signings of estate planning documents, trusts, powers of attorney, health proxies, living wills. This can be done. It's obviously a little more cumbersome, but it's the new way of doing things. We have accomplished it successfully in a number of cases. So during the pandemic, which is, as far as our firm goes, it's going to last a couple of months at least, we will be doing everything remotely. And we have scheduled people for in-office meetings starting in June, which I hope will be viable. And we're going to be exercising all pandemic protocols, all social distancing protocols. I suspect we will be wearing masks for a time, cleaning all the surfaces and following all the protocols issued by the building, the CDC, and all common sense measures. Starting in June, we're also going to have the ability to execute people's documents at home. We recognize that some of our senior population are going to be concerned about going outside, concerned about going in public for a time. So what they can do if they want to get their affairs in order is we can consult by telephone. We have a free consultation. We have a free follow-up consultation. After they have a chance to consider the information we provided, they receive a copy of my book in the mail, and we draft an estate plan, send them a proposal. So we can do all that by phone, and then ultimately we can actually sign the documents at their home. Our lawyers, again, subject to all social distancing protocols, will be able to go to people's homes and execute estate planning documents. So something new, we'll be able to actually do estate planning from people's own homes if that's what their wishes are. So as I say, in-office meetings are scheduling for June now. They're available to schedule in June now. Otherwise, for April and May, everything is being done remotely. I want to thank all of you who sent in questions. I'll be answering some of them. But today, we want to talk about revocable versus irrevocable trust. And Revocable trusts, people have different levels of understanding, but generally, revocable trusts are a will substitute. They, since 91, so we're running about 30 years, trusts have become more popular than wills for seniors for a number of reasons. Many of you know this, so bear with me, but we do have some people who are not completely familiar with trusts who are turning in to learn about the differences between them. So first we have to explain what a revocable trust is. It's a legal device that allows you to handle your own affairs for the time being, but appoint somebody else to handle your affairs when you die or you become disabled. So let's first talk about disability. A will, and one of the main drawbacks of the will is there's no plan for disability. And with advances in medical science, better nutrition, they say today, about half of all people will become disabled, usually later in life. But by disabled, I mean unable to handle their legal and financial affairs. So the law concerns itself with who's going to handle their affairs for them. And for that, we have power of attorney, somebody to handle legal and financial affairs. We have healthcare proxy living wills, somebody to make a medical decision, including end of life, pull the plug, so to speak. We use trust for disabled persons. We have guardianship proceedings for disabled persons. This is all the area of elder law. But the problem is, if you only have a will, that is not a plan for disability, and you subject yourself to the state's plan, which is guardianship proceedings. If you don't have a plan, the state can step in through one of the local courts and appoint someone called a legal guardian. This can be a stranger to the family, and that person takes over the assets and decides how they're going to be used. And furthermore, you end up with likely the state plan, which is basically spend it on mom or dad until there's nothing left. The reason people use trust is they're actually taking back control from this guardianship state-appointed system and putting themselves and their families in charge. So what a trust does, a revocable trust, it puts you in charge of your affairs. So let's say your name is Mary Jones, you become Mary Jones trustee, the Mary Jones Living Trust. But the trust allows you to name a successor trustee so that if you become disabled, so-and-so takes over. And this actually prevents or blocks a guardianship proceedings from occurring because the judge cannot appoint a legal guardian over trust assets. The trust trumps the guardianship. So we like the trust because we want to put control in the family, not just because the people you know and you love and you trust and are going to act in your best interest, but they have planning options and asset protection options that the legal guardian doesn't have. For example, under the law, even when somebody is on the nursing home doorstep, we could protect at least half the assets. And this is actually a technique called the half-a-loaf planning, after the expression, you know what half a loaf is, obviously, better than none. So with half a loaf, you can move to protect assets, provided the family's in control, and they have the right to move the assets. Now, in every Ettinger plan, the successor trustee is given the control or the power to move assets out of the old person's name, which is essential because under Medicaid, it's move it or lose it. And if you can move it, which you can, and you can move an unlimited amount under the Ettinger documents, then you can save at least half on the nursing home doorstep. Obviously, those documents have to be set up when the person is well. Can't wait till you need it, it's too late. So I can save half on the nursing home doorstep. A little later, I'm going to explain how you can save the whole thing, but to do that, as many of you know, you have to plan 5 years at a time with something called the Irrevocable Medicaid Asset Protection Trust. So the first thing we use trust for, avoid guardianship on disability, keep control in the family, you have asset protection options, and you can save at least half. The second main reason we use the revocable trust is to avoid probate at death. As many of you know, I was a litigation attorney for 11 years, from 1980 to 91. And if we go back, late 1990 was when I first caught wind of the concept that if you set up a trust, you don't have to go to court to sell the estate. Well, imagine this. I had litigated a number of estates, had a lot of will contests, And when I heard that you could avoid a court proceeding at death, I was very intrigued. So naturally, I looked into it. I found that not only was it true, that if you set up a trust, you don't have to go to court to sell the estate, but at that time, the best estate planning lawyers were in Florida. So I went down to Florida, got trained as very good estate planning lawyers, came back. I closed my litigation practice, founded Ettinger Law Firm, April of '91, to keep our clients out of court. And I like keeping clients out of court because it's a place where you don't have any control over what's going to happen. I like my clients to be in control of their affairs. Everybody wants control of their affairs, and I want that for our clients. But when you go to court, obviously the judge is in charge. You're subject to what the judge decides. The judge doesn't always act in your best interest. The judge can make a mistake, naturally. But it's basically whatever the judge says. When the judge says jump, the answer has to be how high. And sure, if you have to go, you have to go. But if you don't, well, why would you subject yourself to that type of time and expense and potential pitfalls of a court proceeding when you don't have to? It's almost like minor surgery. It's not minor if it goes wrong. So you want to avoid surgery if you can, but if you have to, you have to. If there's other ways around it, always better to try a less invasive alternative, which is what a trust is, less invasive of your personal rights than a will. So like trust to avoid guardianship, avoid probate, keep control in the family. I had a client, I'll just give you an example of a will proceeding. A client his father died here in New York. He had a house in Virginia. So my client, who was named executor under the will, went ahead and listed the house for sale, found a buyer, signed the contract to sale, and then sent me an email saying, Mike, could you probate the estate so we can go to the closing? Well, I had to write him back and say, Brian, what did you do? You can't list the house for sale and you can't sign a contract to sale until the court has approved the will. You're not appointed guardian. You're not appointed executor. I said, it's going to take about 2 years between New York and Virginia. Then he says, okay, well, that's terrible. First of all, he had to undo the transaction and pay all the buyer's expenses. But then he wanted to rent the house. And I said, well, you can't rent it because you can't sign a lease agreement. Actually, you have to carry the house empty for about 2 years to sell the house in Virginia, because you have to probate in New York and then in Virginia. Now, when I say 2 years, it's an estimate. It could be a year and a half, it could be 2.5 years. But meantime, he has to carry the house empty because his father had a will. Now, if his father had a trust, he could have sold the house the very next day after his father died, of course, if he wanted to. But the point is, he had complete control. Didn't have to ask anybody's permission. And that's what it's like in the real world. In one case, you're in charge, you do as you please. In another case, somebody else is in charge and they tell you what to do and when to do it. So this is why trusts have become so popular. We use trust to also to keep assets in the bloodline. These are also other forms of revocable trust, but generally, a will leaves your assets to your children in equal shares. But what happens if your son or daughter inherits from you and they die? Some years after you, 5 years, 50 years, whatever. When they die, if they have a spouse, generally goes to their spouse. That spouse can get remarried and share the money you left with a complete stranger. So very popular today in the revocable trust field, there's something called inheritance trust. You set up a trust for your son, for your daughter, the money goes to the trust. So it's the married, let's call her, Sandy Jones, Mary's daughter. So she has a son, Bob Jones. So half goes to the Bob Jones trust, half goes to the Sarah Jones trust. So it goes to the daughter, goes to the son. Each of them have their own trust. They're each in charge. They can do whatever they want with the money. They could spend the whole thing. But it's protected if they get divorced. Divorce rate's 50%. Protected if they get sued. But the main thing with these inheritance trusts says, when my son or daughter dies, whatever I left them, the inheritance passes by the terms of this trust. So you can say, well, if my son or daughter dies, I want to go to my grandchildren, not my son-in-law or daughter-in-law, and get remarried and share with a complete stranger. So we use inheritance trust, very popular today, been mainstream for more than 20 years, actually. to keep assets in the bloodline, protect that inheritance from divorces, lawsuits, and creditors. So revocable trusts are excellent tools. We have done many, many thousands of them. They're very popular. They're used to avoid probate of death, avoid guardianship on disability, keep assets in the bloodline. But the one thing a revocable trust doesn't do, it doesn't protect assets from long-term care nursing homes, because in a revocable trust, you could take it out at any time. So if you have to go into nursing home, you're going to say, Mary, well, you can get it, take it out and give it to us. If you could get it, they could get it. Starting at 70, give or take a few years, people start to see irrevocable trust. This one is the famous trust you set up 5 years ahead of time, protects your home and life savings. Now, there are some differences, obviously, between revocable and irrevocable trusts. The irrevocable trust does most of what the revocable trust does. It avoids probate of death. It avoids guardianship on disability, can keep assets in the bloodline. But the revocable trust also sets up 2 roadblocks that Medicaid and nursing homes can't break through. The first roadblock is you have to name somebody else as the trustee. Because remember, the trustee is in charge, the trustee can take it out. So usually you pick 1 or more of your adult children. You can pick any number, but it gets a little cumbersome. 3 is a little cumbersome, but 2, it can be 3 if it must be, but generally people pick 1 or 2, and you can have them act together independently, although acting independently gives more flexibility, allows either trustee to act on behalf of the trust. And so the son or daughter becomes a placeholder. They actually are acting in your instructions, but their name is on the trust as the manager, of the trust. So they manage the trust. What does this mean for you, the client? Well, you still own the assets. You're still the beneficiary. So you still have the exclusive use and enjoyment of those trust assets, but they're the manager, like a figurehead. They act, for your benefit. So somebody else is in charge, but you have the benefit. The second roadblock is in a Medicaid trust, you must limit yourself to the income only. And in fact, we call them income-only trusts. And it means when it says you put in stock, the income is the dividends. You only get the dividends. You put in CDs, you only get the interest. So the income is the interest, you only get the interest. You put in your house, however, it doesn't earn income. So you get the equivalent. Exclusive right to live there, use and enjoy that property during your lifetime, like life rights. What happens to these assets? They stay in the trust, and they go to your heirs, free of the expense and delay of a probate. So who is setting up these Medicaid trusts and why are they doing it? Well, middle-class people, generally 70, give or take a few years, have a lot of assets you're not going to spend, like your home. For heaven's sakes, move to protect your home. What happens if you own a home and you end up in a nursing facility? Well, they put a lien on the house, and eventually, in many cases, the lien gets bigger than the house, and the county walks away with the house. And this is totally unnecessary. For more than 30 years, in the great state of New York, you're allowed to take your house, put it into a trust, Medicaid Asset Protection Trust. Anytime after 5 years, if you need care, they can't touch it. Now, I first learned of this 30 years ago when I started out. I've been a lawyer for 40 years. This is my 40th year at the bar. I was admitted in 1980. But of the 40 years, the last 30 now has been elder law estate planning. And when I first discovered 30 years ago the Medicaid Asset Protection Trust, which was pretty much in its infancy at that time, I was astounded by what a wonderful product or service this actually is. I mean, but what could be better than having your cake and eat it too? You have the use and enjoyment of your house, and it's protected if you need long-term care. So, we've done it for many, many thousands of people, but there's people who don't do it. And I suspect that of the people who don't do it, there's 2 major reasons. One is many people have never heard of it. So obviously never heard of it, you can't do it. But more interesting, perhaps, is the fact that a lot of people get the wrong advice. And I want to state this delicately, but accountants and financial advisors often advise clients in these areas, and it turns out the advice is often wrong because they're not familiar with Medicaid or estates or trusts, or even estate taxes. So to get the right advice, without sounding too self-serving, doesn't have to be us, but we recommend you talk to an elder law attorney. Elder law attorneys are used to filing Medicaid cases. We know the rules. We have filed at Ettinger Law Firm over 4,000 Medicaid cases. So why take your advice from someone who hasn't filed one case, which is the financial advisor or the accountant? Take it from somebody who's filed 4,000 cases. And it really is not just a matter of filing those cases. It's a matter of understanding how Medicaid applies the law. You can't just read the law and understand what it says. You have to know how it's interpreted by the person who's providing the services, which is Medicaid. And that takes experience. It's just no substitute for it. So, get the advice from either ourselves or other elder law attorneys. And when I say elder law attorney, I mean something specific. I mean an attorney who only practices elder law. I had a client asked me if their real estate lawyer could do the Medicaid application. I said, well, not successfully. I mean, a Medicaid application is about 2.5 inches thick. How would they know what to do or how to do it? So there's a lot to it. Don't underestimate the complexity. We make it simple because we've been doing it for 30 years. But if you're doing it for the first time, it's extremely difficult. So back to the irrevocable trust. It has those two roadblocks, as I said. Income only. Somebody else has to be the trustee. Then we talked about, who doesn't do it, people who get the incorrect advice. And I want to say a few things about some of the misconceptions about the irrevocable Medicaid Asset Protection Trust. People come in regularly and say, somebody told me that if I set up an irrevocable trust and I put my house in it, I can't sell the house. I say, well, there's no such rule. I don't know where you got that advice, but it's incorrect. We've done it thousands of times. At any time, the trust can sell the house. The money's paid to the trust. The trust can go out and buy a condo. It doesn't start the 5 years over again. Again, incorrect advice. I bet thousands of people were told this over the years, didn't do anything, they were afraid, and they ended up losing their home. So get the right advice. Next person comes in and says, somebody told me that if I put my house in the irrevocable trust, I lose my exemption, senior, veteran, star. Well, no such rule. What happens is the assessor wants to see a copy of the trust to see under the trust who has a right to live there. You have the right to live there, you keep the exemption. So it's just a proof problem. I don't recall one case in the countless thousands that we've done where we've lost an exemption. Again, incorrect advice, and then people don't act and get the benefit of the trust. Then there's the 5 years. A lot of people have a misconception about the 5 years. And it's natural because you think, well, if it takes 5 years, you have to make the 5 years. But it doesn't actually work that way. It sort of prorates. So let's say you set up the trust, and 4 years later, you have to go into a nursing home. You only have to pay for the 1 year that's left. So in other words, it pays to get started, even if you don't make the 5 years. So do you need a revocable trust or an irrevocable trust? Well, you certainly don't need both. You need one or the other. The reason being, if you set up an irrevocable trust, you have to put most of your assets in it or it's not benefiting you. You might leave out 100 or a couple $100,000, but for that, you don't need the other trust. You can name beneficiaries on the bank account or the investment account. So that's sort of a primer on a revocable or irrevocable trusts. I'm going to answer some questions, but I will tell you on our website, which is trustlaw.com, you can watch videos of my estate planning seminar. You can actually plan your estate. You can plan it on ettingerplan.com. We took out a new a website for that, and it gives you instructions on planning your estate. If you want to do it or you want to refer somebody, by all means, send them to ettingerplan.com. I'm going to go ahead and bring up some of the questions. I think you'll find them interesting, the question and answer. This was from Sheila Strait, who asked if I put my house and money in my children's, I think if I put my house and money in an irrevocable trust, when I die, do the children get it automatically, or do they have to go to a lawyer to get it? Well, the irrevocable trust actually has an advantage in settling the estate, because the sons and daughters are already entitled. Their name are on the assets. Yes, as trustees, but they have control. There's that word again, control. So they can actually settle most of the estate themselves. If there's inheritance trusts, well, to keep it in the blood, they may need our help. But we find the cost of setting up an irrevocable trust is fairly minimal because, again, the titles have already been changed and the children are in charge. So they probably will want some legal advice, but the costs tend to be small. Here's a question from Steve Kahn, who says, can a trust own two homes in different states with different owners? One house is owned joint and the other by a spouse only. And the answer is absolutely yes. You can transfer a half interest to a trust. If you own a property with a brother, you can take your half, as I say, put in the trust. You can do property from any of the 50 states. We can deed into the trust. Ettinger Law Firm, actually, we use a firm called US Deeds, and they prepare and file the deeds in all 50 states for us. We have to do the paperwork with the client, but they prepare it and file it. So the answer is yes. Here's a question I thought interesting from Rita Manley. Thank you, Rita. How is it best to leave the home to your children? In this case, spouse wants to leave it to their husband first, daughter second. This is where we get into something called the deed with the life estate, a popular technique amongst general lawyers, but actually not amongst estate planning and elder law attorneys. So what a lot of people do is they'll deed the house to son or daughter and reserve the right to live there. Life rights, life estate. So they keep the exemptions, they own the house for their lifetime, and when they die, son or daughter owns it automatically. So why is it that elder law attorneys don't do that? Well, it has some pitfalls. If you deed the house to your son or daughter and reserve the right to live there, you become exposed to their debts and liabilities because they're on the deed, their divorces. If you want to sell the house and the son or daughter won't sign, you're in trouble. Nothing you can do to make them sign. You lose control, you give them up control. We like the trust because with the trust, if the son or daughter won't sign, we could take them out, put somebody else in, and have the other person sign. So you keep control. And control is of essential importance to us and to our clients. Because one thing we can be sure of, people will change their minds. It's what people do. And what we want is when a client changes their mind, we want to be able to say, not a problem, we can fix that. We can do that. You have the flexibility. You're still in charge. You have options. We don't want to paint anybody into a corner, and we don't. So the deed with the life estate also has this drawback. When you sell your house, if it's your primary residence, you can exclude the capital gains tax. $500,000 for a couple, $250,000 for a single person. But if you've done a deed with the life estate, you lose most of the exemption because the sons and daughters are the owner of the property. So you decide to sell, you're going to owe capital gains taxes, and you wouldn't have owed if you put it in a trust, because a trust preserves the exclusion from the capital gains tax. So elder law attorneys, essentially, we have a better tool for the job. The trust is a better tool. Why don't other lawyers use it? Because they don't know how to do it. They're not elder law attorneys. So any attorney can prepare a trust, which is why you get all these deeds with the life estate. But most of the attorneys who are doing that are general lawyers. They're real estate lawyers. They know how to prepare a deed. But they don't actually, most of them even know the consequences of doing with a deed with the life estate because they don't deal with disability and elder law in general. So they don't see it through to completion. It's a problem later on that their client will find out. From Sheldon Friedland, I'm sorry, Sheldon. Here's an interesting question. If I have a pay on death or a beneficiary designation on my bank and my stock accounts, and I have power of attorney so somebody can handle my legal and financial affairs if I become disabled, I have my health proxy living will. If I have everybody on everything, why would I need a trust? And I've been asked that question often. You have pay on death, or joint with everybody, so there's no probate. And there's the answer right there. I mean, there's no probate, but it's not an estate plan. Doesn't keep your assets in the bloodline. Doesn't protect that inheritance if children get divorced or sued. No nursing home protection. So you may not have the assets, even though it's POD. There's no asset protection on POD. I mean, pay on death. There's no asset protection there. You own it, and if you need care, those documents are available for the cost of your care. They're available to be spent down, is the Medicaid term. So, sure, it's a good thing to have, but it's not an estate plan in itself. From Dennis O'Grady, what should be and shouldn't be in trusts? Well, you want the trust to work to avoid probates. You want to put in the probatable assets, which are even joint assets between husband and wife. When the second one dies, there will be, joint, first one dies, goes survivor. When the second one dies, there will be a probate. So jointly held assets, everything except retirement accounts, IRAs, 401ks, 403bs, 457s, all plans now defer to age 72. Used to be 70 and a half, but under the Secure Act now defer to 72. All retirement plans are exempt from Medicaid. They can't touch them. Not only exempt from Medicaid, but they're also exempt from probate because they have a designated beneficiary. Now, it's true, if in a nursing home, you're probably over 72, so you're likely taking your required minimum distribution. Medicaid gets the RMDs, required minimum distribution, but the IRA itself is exempt. They can't go into the IRA and get the money out of it. They can only take what you must take. Next question, from Amy Corcoran. Amy, thank you for writing. Should couples in their early 50s think about this? Well, once you have any assets, you need some sort of plan. We generally don't recommend trusts for people in their 50s unless they have a taxable estate. And taxable estates are basically $5 million or more. If you have an estate of $5 million or more, you have an estate tax problem, and you have to solve that before the first spouse dies. So if you're in your 50s, if you don't have a estate 5 million or more, which of course is most people, you still need a plan, but you don't need a trust. You can get by with a will. Certainly need power of attorney, health proxy, living will, so somebody can handle your legal, financial, and medical affairs if you become disabled. So you need a will, and then at Ettinger, we review it every 3 years. So, somewhere in the future, if you need a trust, we'll let you know. We'll recommend that. But this is something exclusively about our firm, which is we review our plans every 3 years. There's no charge for that. And we track them. If there's a law change, we'll tell you. Now, I see some of you raising your hands, but I don't think that I will be able to answer you online during this talk. So just email me with your question, and I'll answer you by email. And thank you for participating. Somebody asked, this is Jody Kavanaugh, they're interested in setting up a trust, possibly with video and credit card. Well, as I said, we have been doing that. We do have the capability of doing it. Obviously a little more cumbersome than the good old in-office meeting, but we're getting better at it. All the protocols are in place. The governor has issued orders allowing us to do remote notarization, remote witnessing. So the answer is yes, we can do it, and we are doing it. Here's a question about, this is from Nancy Badgley. Nancy wants to know about getting a mortgage on an asset that's in a revocable trust. Generally, banks don't want to lend money to assets against an asset in a trust, because the bank wants to bundle that loan and sell it with a bunch of other loans to a third party, and the trust doesn't fit into the bundle. Nevertheless, it's very simple to take the house out of the trust, get the loan, and put it back in, because under the Jackson-Vanik Amendment, federal law, you're allowed to put your mortgage property into a trust. They don't have to give you the loan, but once you have the loan, they can't prevent you from putting it into the trust. So you take it out, get the loan, put it back in. We do have lenders. If you contact me by email, we have lenders that will lend on revocable trust. We have lenders that will lend on irrevocable trust. We have a couple of them. So you can get loans, you can get reverse mortgages, even if you have a trust. But again, if you need a lender, contact me by email. And my email address is mettinger, METTINGER, Trust Law, one word, trustlaw.com, mettinger@trustlaw.com. Here's a question who's from a client, Cristiano Frank, asking if the house and trust is protected from title thieves. Let me talk a moment about title thieves. Clients have been coming in lately. It seems this has been especially going on in the Queens area, but you know, a scam is successful, will work everywhere. But what people are getting, they're getting letters saying that their title could be forged or altered, and they're offering deed title protection or deed protection. This is a scam as far as I'm concerned, because it's extremely difficult for somebody to steal your deed. I don't think you need this type of protection. Your deed is recorded, it's notarized. It's very, very difficult for somebody to steal a title, and also you're going to notice somebody coming through your living room. You know, there's the paperwork, but then there's the actuality of somebody taking over your home. Extremely difficult. So I hope you won't fall for that scam. Is there an advantage? This is Sylvia Spare. Is there an advantage to Florida residency for heirs? Well, again, there's no tax advantage to Florida residency for heirs, at least in estate taxes, unless your estate is over $5 million. Then you do have an issue with New York taxes. And you know, this is something we have to keep an eye on, because the federal exemption may go down. Currently, the federal exemption is $11,400,000 per person on estate taxes. New York State, $5,850,000. But those exemptions may go down depending on the next election and depending on how we're going to pay for the bailout. But one proposal is to bring it back to the 3.5 million we had before the exemptions were raised to these new numbers. So we track all our plans for law changes. If you're in a situation where you would be affected by a tax law change, we will let you know. You'll probably know as well, because it'll be all over the news. Fees. Well, it's very, very difficult to go over fees. This is something that a couple of people asked about fees. Hard to go over fees, because fees on estate planning range from $750 to $7,500, depending on, some people just need a power of attorney, and we don't want to turn them away. That could be the most valuable document they ever prepare. It's a crucial document that everybody should have in any event. Some people need revocable, some people need irrevocable, some want the inheritance trust, some don't want the inheritance trust. But I think that you know, we know what the marketplace is, been at it for a long time. We're not the least expensive, we're certainly not the most expensive. I think we give very good value, because a lot of firms, it's thank you very much, goodbye, but as many of you know, we don't say goodbye. We track our plans. If the law change, we'll tell you, and we have a free review every 3 years. Our plans are actually designed to work when you need them, not when you wrote them. You know, could be hopefully many, many decades earlier. So I think we give more value for what we charge, but we always encourage clients that if they want to know, well, you know, by all means, go talk to somebody else and see, you know, who you would prefer. Again, irrevocable trust, question about mortgages. It does not affect your ability to get a mortgage. We have lenders that will lend on your revocable and irrevocable trust. Here's somebody, a lot of people ask me about the durable power of attorney. Since 2009, all powers of attorney are durable. They changed the law. It used to be you had a regular power of attorney which ceased if you became disabled, and the durable power of attorney which continued if you became disabled. And today they're all durable. In other words, they all continue if you become disabled. It's built in, it's automatic. Okay, here's a question from Anna McGuire. Thank you for writing, Anna. if I put my money in an irrevocable trust to protect it from a possible nursing home situation, how do I access my money from an irrevocable trust on a weekly or monthly basis? Good question. So the irrevocable trust is an income-only trust. You only get the income. But what if you need principal? Well, there is a way to get, and you can take the income weekly, monthly, however, it's distributed by the trustee through the trust checking account. But what if you need principal? You can't directly take out principal, because if you could get it, the nursing home can get it. But you can make a gift out to one of your children. Because when I apply for Medicaid, they're going to ask me, what did you take out of your name and put into that trust? But they're not allowed to ask what the trust gave to somebody else. So you, let's say you need $50,000 to buy a new boat. You make a gift of $50,000 to your son or daughter. They can't give it back to you, because if I apply for Medicaid, I have to show them all your bank accounts, and they're going to see 50,000 came in. They're going to say, where did that come from? But it came from the trust of your son, so they can't give it back to you. But if you give them the $50,000, there's no taxes on that. It's a tax-free transaction, and they can take that 50, go buy the boat with their money, so they can spend it on you. You have a bill, you can hand them the bill, they can pay the bill. So you have the gifting power. And the other reason I'm such a big fan of the Irrevocable Medicaid Asset Protection Trust, and I think somebody asked this question, probably get to it later on, but in New York you can revoke an irrevocable trust, which sounds very strange to people, but there's a reason for it. It's irrevocable because you folks, your people set it up, you're called the grantors, you can't revoke it yourself. But there's another provision in the law that says that if every person named in an irrevocable trust agrees in writing that they no longer want the trust, you may revoke it on the written consent of all the named parties. Well, this is you and your family. So if you and your family all sign, you can undo it. What if one of them won't sign? Not a problem. I'm in the trust, I take that person out, and then I revoke it on consent of the named parties. In essence, you can always revoke an irrevocable trust. And this is why it's such a cake and eat it too. And you've got the protection running, you decide you need the money, you want to do something else, you got to do it, take it back. I had a client a couple of years ago, wanted to had an irrevocable trust, but they wanted to buy into Jefferson Ferry. Jefferson Ferry is in Port Jefferson on Long Island, and it's a continuing care retirement community, a CCRC they're called, continuing care retirement communities. And basically you go in, they have independent living, they have assisted living, and they have nursing home all on the premises, on the campus. And so this way, when you buy in, you actually buy the nursing home. You don't need the irrevocable trust. It's included in the purchase price. So I said, no problem, Bob. We can undo your trust, take back the money, you'll buy in Jefferson Ferry. Again, it's about control. The client has control. And this is where, if I was a client, this is where I would want to be. And so this is what we do for you. See if there's anything else here. If one spouse has a Medicaid trust, can the other spouse do the same? Well, you don't need two Medicaid trusts if you're a couple. The one trust will work unless you're over the 5 million, but then you need two trusts to save the estate taxes. But generally, for almost the vast majority of clients, one trust, it runs for the combined lifetimes of the spouses. So a husband dies, it just carries on to the wife dies, and vice versa, and pays out on the second death. So the protection runs for the combined lifetimes, and the use and enjoyment of the assets runs for the combined lifetimes. Not unusual, done it countless times. Is it ever too early to do an MAPT? Well, generally we like to do it around ages 70, give or take a few years. Because of the 5-year look back, we want to get it going. I don't think you need it when you're 60, unless you have a health issue or you have a family history that makes you concerned. So I'm not sure, absent those issues, I'm not sure you want to set up the trust and do all that noise. The average age of a nursing home entrant is today about 87, 88 years old. So, I think if you're of average health, you can wait till your 70s, late 60s, early 70s, ideal time. Somebody asked, I think this was Anthony Gambino, asked about filing taxes. Revocable trusts actually do not require a tax return. A revocable trust uses your Social Security number, and you don't file a tax return. All the answers are the same as yours, so just file the same income tax return as if you didn't have the trust. An irrevocable trust has a trust tax ID number. It's a separate legal entity, so it has to file a return. But there's no taxes due. What it has to file is what's called an informational return. And an informational return says, I have this trust, the income is payable to me, I'm going to pay the tax on my individual return. So it tells the IRS that you're going to collect the income and pay it on your individual return. So the trust doesn't pay the tax, you pay the tax exactly the same as before. So with the irrevocable trust, there's a reporting requirement. It's actually a one-page return. It's got a lot of zeros on it, and it just informs the IRS that you'll be paying the tax individually. No problem with that. Interesting question about client had an attorney left their firm, and then another attorney, with her permission, took over the file, but is unresponsive to her. She's wondering if it's ethical to take the file and move to another attorney. It's an established rule that every client has an absolute right to terminate the legal relationship whenever they wish, to move to another attorney. You're the client, so you're actually in charge. It's not unethical in any way to take the file, move to another attorney, especially if they're unresponsive. So the way that's done is you generally will call and make an appointment to pick up your file. They'll prepare it, and they'll have you sign something when you get to the office acknowledging that you took the file, and you're good to go. It can be done by mail as well. So don't feel that you are bound to any particular lawyer. You're always free to choose the lawyer of your choice. Do revocable trusts, Robert Nickel. Do revocable trusts require any distributions before the death of the grantor? No, they do not require distributions before the death of the grantor, but you have the option to make gifts before the death of the grantor. From Robert Presland, if we have our house in New York and buy it and sell it to buy a house in Connecticut, do we have to redo the trust? No. Trust is good in all 50 states. You can sell the house, the money's paid to the trust will go out and buy the place in Connecticut. Here's a question about the inheritance trust. I think we talked about that. Here's Anthony Emin has a home in Long Island and one in Las Vegas, and his income is the rents from the homes. So if he puts his homes in the irrevocable trust, he'll be able to get the rents without the permission of the two trustees. Actually, yes. When we do these trusts, we don't really need to advise the tenants of the trust. They keep paying the rent the same as before, and they'll pay it directly to you. No need to change that. Even in an irrevocable trust, you're entitled to all the income from the trust. The rents are income, so the rents can keep being paid to you directly. Not really a problem. Somebody asked me, I think it was Bill Elliott, they see in the bank, it says the name of the trust, and it says UAD, U/A/D. And what does that mean? Well, it means under agreement dated. So the Jack and Jill Trust, UAD, under agreement dated, 6/12/20, whatever. So UAD, U/A/D means under agreement dated. It's just a short form. Yes, here's something, thank you, Linda Brenner, for bringing this up, about the government's proposed changes in Medicaid. They haven't changed the 5-year look back on the irrevocable trust, but they just changed the look back for community-based care, which is home care. You used to be able to get, there was no look back. Basically, move the assets, next month later, you could apply for Medicaid. Now, they've created a 2.5-year look back for community-based Medicaid. This is going to create a lot of hardship for people. I'm really saddened by this news. but nevertheless, it's a reality that we have to deal with. And what it means is that people now will need to plan sooner and be more aggressive in their planning, because the government is getting more aggressive in taking back your assets. You know, they wanted people to stay at home. That's why they made it easy. Keep them out of a nursing home. It's less money for the state to pay for their care. But this is going to make it far more difficult to get home care. And how people are going to pay for home care for 2.5 years if they don't have something set up ahead of time is something that's going to be very, very difficult. So now planning has become more important because of the 2.5 year look back on community-based Medicaid home care. So I want to thank all of you for attending our virtual meeting. I wish it could be back and forth, but that doesn't really work with a couple hundred people online. I will be on again next week at the same time, 3 o'clock. You will get a notice. If you signed up for this one, you will get a notice, and you can, of the meeting, you can send it to anybody you like. We have capacity for up to 500 people, and we hope to see you again, and please send in your questions. On the invite, you'll have a place to send your questions. As I said, you can email me with your questions. Happy to answer them. mettinger@trustlaw.com. Next week topic. Next week, I'm going to talk about trust generally, but I want to maybe focus on planning for dependent children. And dependent children are those who can't support themselves or cannot handle money. And I would say, just anecdotally, about 1/3, somewhere between 1/3 and maybe a little more, of people who come to see me over the years have a son or a daughter, or more than one, who either cannot support themselves or do not handle money well. So I'm going to talk about some of the issues there and some of the possible solutions. At the same time, I think I'll talk about special needs children at that time and talk about the special needs trust and cover all those bases. There are options, and it gives a client peace of mind to know that they have a plan so that the inheritance won't be wasted, the children won't be destitute one day, that somebody will be helping them with that. So with that, I want to thank you for listening and attending. I want to wish everybody a happy Passover for our Jewish clients and friends. I want happy Easter for our Christian clients and friends, and wish everybody the best to stay safe and survive the pandemic as best everybody can. Thank you very much. Bye-bye.